technology transfer. So these are two different domains. Because when we are talking about technology transfer, it's completely on the tech part. And when we are talking about the licensing and other agreements, it's pure legal form of it. So I'll try to explain everything in simple language so that, like, I suppose the people here are not with legal background. So I will try to explain in simple language. And so are we going to take question answer session at last, or it can be taken in between as well?
Ma'am, it's your freedom. If you want, so there is a flexibility. If you want, you can break in between for 15 minutes and then have a round of question answers,
Yeah.
and then you can resume your session. So it's up to you. Otherwise, we said we have actually 1.5 hours for the session and 30 minutes for the question answers.
Sure. Yeah, that would be great.
Yeah, ma'am. Just one more thing. I think you will have to put your presentation in the presentation mode.
Can you see it now?
Yeah, now it is visible, ma'am, on full
Okay.
screen. Thank you.
Because see, if when I'm presenting like this, I can't see anyone. So it's very difficult. It's like I'm talking to my laptop,
Right.
right?
Particularly with Google Meet, I think we have that problem.
Correct.
Yeah.
No, that's fine. So if when we are talking about role and importance of licensing in technology transfer, so first, what is technology transfer? So in very simple language, or maybe layman language, I can say transferring the technology from laboratory to market. Okay. So because when the research scholars, they work in the lab, do a lot of research, and after that for them the objective is to publish the paper, and then it's done. Like they would be writing all these things in resume, like we have published like 10 or 15 papers, I have filed 5 to 6 patents. And then usually people are not interested in commercializing the technology, which is very important for the person who worked on the technology and also for the economic growth of the country. So covering this, my presentation is basically divided into 3 parts. One, I will cover the basics of technology transfer, then the license agreement and what are the requirements of for that. And after that, I will cover some case studies to understand like how does it work. Okay, so if you have any questions, please don't hesitate to interrupt me to answer any question as we go along. It would help to explain things in detail. Okay, so let me start it. So when we are talking about technology transfer, so you can see the technology is being transferred from a person or organization to another person or organization. Okay, this covers the process of sharing skills, knowledge, know-how, process of manufacturing the product, and all other technical details. So when we are saying the transfer, it can be from an individual, basically anyone who is working on the research. It can be individual inventor or group of inventors. It can be university or research organizations, and it can be a small industry also, like small industry who is not capable of manufacturing and commercializing the product the large scale. So all these people and organizations, they can transfer their technology to an industry which is capable of production of the product and commercialization. That means selling the product in the market. So these are the basic steps when we are talking about technology transfer. So usually it starts with an idea. And then we will have to evaluate the idea to understand whether it's feasible to prepare a prototype, or whatever research findings are there, it would help to get a final product, or to understand whether the research results would be positive or not. So once we evaluate the technology, after that we start innovating it. Then that research and development falls here. And once the research is done, before discussing it, we should protect it. After protection, we can market, and then negotiation, licensing, and then commercialization. So I will start by one. So evaluation and innovation, I suppose I don't have to explain it here, because like all most of the people are with technical background and with research background, so they know like how to have an idea and then how to implement it in the lab. Okay, how to work on this. So when we next step is the protection of the technology. So when we are talking about protection of technology, so there are multiple options. One option, we can keep it as a secret. That means we cannot disclose or publish anything about the technology with anyone else or like any online portal. It's not easy to keep a secret the technology, because you would be using it, then it's difficult to hide it. Okay, a lot of time would be taken, and it's very expensive, and it's not very possible to keep it as a secret. So other option is to publish the invention. So we usually call it as defensive publication, where I am publishing my technology, and then I will actually stop others to protect the same and similar technology. Because when we are talking about protection, if I am not protecting my technology, there are other people who are working on the same and similar technology. Later on, if they come up with any innovative idea which can be patented, so if we have already published it beforehand, then the those people or maybe companies or research organizations, they won't be able to protect it. So it will help me to have freedom to use any kind of technology. The third and important option to protect the technology is through intellectual property right. So usually technology is being protected under patent laws. And so there are some basic criteria. When we are talking about patent, so the invention, it should be novel and new. So when we are saying novel, that means it should not be available in like, anywhere in India or world. Like no one should know about the invention before we file the patent application. Even you, like inventor himself, cannot publish the application without filing it. It is not suggested. And if the investor or small companies or tech companies, when they are going to talk with investors to conduct the research at a large scale, it's always advised to file to sign one non-disclosure agreement with them. It will help to save the novelty. The other criteria is the inventive step. So, as per law, the invention should have at least one inventive step. That means it should not be obvious for other people who are working in the same technology. Okay, we should have done something which is not known in the prior art and which is not obvious for the people with similar skill set. The third criteria is industrial use. So all the inventions which are applicable for patent, they should have ability to use in an industry. So when we are talking about patents, it's time consuming and expensive, but it gives stronger protection, because once you have patent, you are having kind of monopoly, and you can stop others using your technology. And but you can license it to others, or maybe you can assign your patent or technology to anyone else who is interested. And filing patent application is a complex process. Then it is always suggested to like have one attorney or patent agent who can help you to understand the requirement for patent application, and they can assist you for for filing patent application, and they can assist you at each step from filing to the grant of patent. So when we are talking about patents, we will have to decide like which country should I file my patent. So as like it's a the patents law are bounded by legal boundaries. These are territorial in nature. That means if you are protecting your invention in India, it will be valid only in India. So if you want to protect your invention in other countries, you will have to protect the invention, or you will have to file the patent application in each required country. So there are multiple options for that. And so, like, how do you decide the country? So, you will have to assess the market. You will have to see whether you have business in those countries. Then only it is suggested to file the application in multiple countries. Because it's, as I told you, this is expensive. And if, for example, you want to file patent application in US, you want a granted patent in US, but you are not going to commercialize it in US. So there is no point spending a lot of money on filing the application, and after the grant you will have to maintain it. So it is like not recommended. If you have market and business in other countries, then you should protect it. So apart from patents, there are different forms of IPR. I'm not covering everything in detail related to intellectual property right, because I suppose there are other lectures will be there. So when we are talking about different forms of IPR, it covers patents, which is for invention, then copyright, which is for literary work, artistic work, cinematographic, music. So where we know like you can copyright the book, painting, a photograph, movie, music, all these things. Then other one is trademark. So when we are talking about trademark, it related to the brand or in anything, any mark, any tagline, whatever you use to promote your business can be protected under trademark. It can be the name of the company, name of the product, there can be a logo or tagline to promote the business. So the next option, the other form of IPR is industrial design. So industrial design, this option is to protect the design of any article or of any product. So there is a slight difference between patents and industrial design. When when we are filing patent application, we are covering everything related to the technology. Like if it is related to a product, we cover all the features of the product and the functions, how it works. But when we are talking about industrial design, we cover only the look and feel of the product, like how does it look like. And sometimes there are special designs and they have aesthetic value. Just because of design, you can see there is a lot of sale only because of design. And the other one is protection of geographical indications. So these are the products which have certain kind of properties because of their geographical origin. So we can say like Banganapalli mangoes or Kullu shawl or Darjeeling tea. All these products, they have one specialized kind of property because of their origin. Then another form is to protect the layout of design of integrated circuit. Then one is protection of undisclosed information. This is trade secret. So we don't have a separate law to protect an undisclosed information. So if you have a trade secret with you, you will have to keep it to yourself. And even if you find that someone else is using it, it would be very difficult to prove. Because if you're going to the court and filing a case against the other person saying that the person is infringing your trade secret, you will have to prove that this is your trade secret. The moment you prove, that means you are disclosing your information and the secret is gone. The other form of IPR is protection of new plant varieties. This is related to plant varieties. So if farmers they are creating any plant variety, they can protect it. And so there are different requirements and there's a different procedure for that. So when we talk about licensing in IPR, so obviously IPR can be licensed to other person to use it. Okay, so geographical indication cannot be licensed to anyone because this society, anyone who is using the guidelines and they are allowed to use the name and they are allowed to use the name and sell the product using that name. For all other things, it can be licensed to other people, maybe to an individual or the company as per the interest of both parties. So till now I have covered basics of IPR. Do you have any questions related to IPR?
I don't think they have any as
Okay,
of now.
sure, sure. Then we can move ahead, and then whenever someone is having any question, they like please feel free to ask.
Ma'am, there was a question. It was whether a trade secret can be at later stage made into a patent.
I'm sorry, I couldn't hear you.
There was a question
Uh-huh.
whether a secret now at a later stage can it be made into a patent.
That can be done. See, for filing patent application, it should be new. Like you should not disclose anything before filing patent application. So if you have a trade secret and it is fulfilling the patentability criteria, you can go for patent. The only thing when we are filing patent application, so as per law, it will be published after 18 months. So whatever you are filing, it will be published and available with public. So then it will not be a secret anymore. Okay, because when we are filing patent application, government is giving right for 20 years to exploit the technology, and after years, the patent will go to the society. Okay, so like you have conducted the research, you have spent a lot of time and money. So government is giving you monopoly for a certain period. After that, it will go to the society. And so there is a important requirement for patent. When we are filing patent application, that time we will have to disclose the invention in detail so that any other person after reading the patent document should be able to replicate it. The person should be able to manufacture the same product or maybe to use the similar process using the information given in the patent document. So let's come back to technology transfer. So once we protect the uh, invention or the technology, then we will have to market ourselves. Like if we are looking for a buyer or for any company and I want to license my technology to someone else, we like I will have to tell people that particular technology is available. So how should we tell to others? One is the publication. Like we can publish it on the institutional website, or if you have personal website, you can post it there. There are some tech transfer databases, you can put it there. Then marketplace, and then there are conferences being organized for startup conferences and other similar conferences. You can attend the conferences, present your technology or invention there. You can attend industry exhibitions. So one you already have file patent application now, like you have application number and date of filing, your priority will start. After this, if you want, you can disclose it to others, so it will not hamper your patent process. So after publishing, like you are completely advertising yourself, then you will have to contact potential buyers. You will have to identify like who can be the potential buyers for your technology. You can send email to those people, or maybe you can send multiple to group of people. You can organize promotional events there where people can come and attend and they will get to know about your technology. If you are doing all these things, then investors or buyers, they will get to know about the technology. They can start communicating with you. They will tell that they are interested and this can be taken forward for the next step. So once we have the buyer, then the negotiation will start. Okay, so whenever we are talking about seller or buyer, so obviously there would be one consideration. So when we are talking about for technology transfer, this is to maximize the revenue. Because if I have a technology and I want to license my technology to the other person, then there would be some consideration, and if the company or industry is able to manufacture and commercialize it, it will help to maximize the revenue. The other point is when the products are being commercialized, it will help to increase the reputational impact of the research activities. The people will get to know about the institute or about the research group who worked on that particular technology. One more option, like other point, is to control of the future development of the technology. So if I'm a researcher, I have a new technology and I'm licensing this technology to the company, then I would want to keep a hold of the future development of the technology. So that can be discussed during the negotiation process, like who will own the rights on the developed or modified technology. So at the time of negotiation, confidentiality is very important. Because see, we should not disclose anything which is not required to be disclosed at that moment. So the confidential should be there within the team, within the organization, and within the partners. So when we are saying confidentiality, and then during the negotiation process, what kind of information should we share? What should we do? We should um, limit, or maybe we should make a boundary like around the technology, to divide like which information can be shared and which information cannot be shared. We should not compromise on the value. And then we have already filed patent application, but anyways, like we should not disclose everything related to the technology at the time of negotiating, because there are chances you would be negotiating with multiple companies. Okay, so it is always advisable to prepare an abstract or summary of the technology, so you can just give an overview of the technology with the industry. So once the negotiation is done and both the parties agree to proceed ahead, we need license agreement. So that is the main topic for the session. So when we are talking about license agreement, obviously there are two parties. One is the licensor and other is the licensee. Licensor is the owner of the technology, and licensee is the person who wants the technology so that they can manufacture and commercialize it in the market. And obviously it will be in exchange of money or something else, like it's a legal contract. So consideration is an important part of it. The contract should be written agreement between both the parties. So as I said, this is a legal document. We should take care if there is any dispute. and if we are taking an action against the other person in the court of law, so that time we will have to submit all those documents. So if the contract is not in writing, it's not legally bound, then it will not be admissible under the court of law. So the contract should be written in legal language. It should cover all the clauses which are required for this, and then it should be on stamp paper signed by both the parties and witnesses, and then it should be notarized. Then it is a proper legal document. So when we are talking about licensing, there are two kind of terms. One is licensing in and one is licensing out. So when we are it's very simple. If you see the picture, you can understand this easily. Licensing out means I'm licensing out my technology to someone else. Okay, because I have done the research, but I don't have facilities for further research or to manufacture the product and commercialize it. In that case, I will contact the industries or organizations who are capable of doing all these things. Then I can license out my technology to the industry or to the organization. So if we consider like other side of the table, like from the point of view of the organization and an industry. So there are industries who are interested in licensing in. Okay, so it's like they don't have a research lab, but they are very interested in technology. They want to use or utilize the latest technologies. So they have a procedure in where they licensing in the technologies where the research was done by someone else. And then obviously they would be getting every information related to the technology, and they can start work money map. They, if required, they can rework on the technology, start manufacturing it, and then commercialize it. So if we say like, why should I license my technology? Okay, so the one thing, it will shorten the product development time. If I have created something, I don't have infrastructure, I don't have an industry for the product development. So if I'm going to establish a new industry or new factory for this, it will take a lot of time and money to establish a new factory or new industry for the product development. So apart from that, I can license my technology to an industry who is already having well established factory, and there the product can be developed. So it will help to shorten the product development time. It will help you to launch the product in the market ASAP. And then it will give you entry to protected industries, and it will help to enhance the quality of products and processes. The same thing, if you don't have infrastructure and if the other industry they have infrastructure, you can give license and they can rework on the technology to enhance the quality of product and processes. It will help to increase sales and revenue, and it will give you like a lot of other business opportunities. Okay, so when we are talking about license agreement, there are very important features, or there are different terms which are being used in license agreement, and terms or clauses. So first is so if you see the list, you can see license can be exclusive or non-exclusive, maybe, and the types of right, like what kind of rights would be given in the license agreement, what would be the geographical scope, then what are the obligations of parties, financial terms. Obviously, this is it will explain everything related to the consideration. Then audit of accounts. Then what will happen if there is a dispute between the parties, the IPR, like who owns the IPR on modified technology. Then like there is a requirement of having indemnity clause. then confidentiality, and the term of the license. So when we are talking about types of licenses, it can be exclusive license or non-exclusive license. So when we are talking about exclusive license, this means the licensee is the only one authorized by the licensor to use and exploit the technology. That is exclusive license. Under this situation, even the licensor may be excluded from using and exploiting the technology. So if you are a researcher, you have developed a technology, but you are giving an exclusive license to other industry, then you cannot use your own technology because you have given an exclusive license. So if we see this in from licensor's point of view, this license is not desirable, okay, because licensor is the person who always wants to use his own technology. That is why they may not prefer giving an exclusive license, and they don't want themselves to be restricted or freedom to do the business with others. And then there is one or more issue related to exclusive license. If the licensee fails to manufacture, then the technology is not commercialized. You won't be able to commercialize the product in the market because you have given an exclusive license to only one industry and they are not able to manufacture the product and commercialize it in the market. So there are other options. If we see licensees point of view, they may consider to get exclusive license if they are going to make heavy investment on customized equipment or specialized labor. So if the company who is interested in your technology, if they don't have already set up for the infrastructure to manufacture the product, they might spend a lot of time on money for all this setup. They will have to set up an industry, or maybe they will have to buy equipments, and they might need trained people who would be working on the technology. So in that case, licensee would always ask for an exclusive license so that he should be assured that he's spending money and time and energy, so he should get benefit in future, because like he will have to ensure that the investments are amortized and the profit is made in future. There is one more option when we are talking about exclusive license. Uh, Exclusive license can be given, maybe it depends on certain conditions. For example, it can be given for a certain time or limited time, maybe for 2 years or 3 years as per the requirement. It can be given for a limited territory, like for a specific jurisdiction, and then it can be given to specified use. Okay, because when we are talking about like what other person can do with the technology, we can restrict here with exclusive license. And then there is one more point. We can give exclusive license which can be limited to a time where the licensee can establish the new business. So once the business is established, all the infrastructure is ready, and when they start manufacturing the product, only till then the license would be exclusive license. After that, it can be non-exclusive license. So exclusivity, it may be conditional. They can put a cap on pricing. for example, it's like I'm ready to give you an exclusive license, but obviously the cost would be on higher side. So in some countries it is not allowed because it is not being considered as a competitive process. Okay, and it is important to ensure that the agreement contains appropriate incentives and or penalties to protect the licensor in the event of non-performance by the licensee. So here the licensor can safeguard themselves by putting certain conditions in the license agreement, so that if there is any default from licensee or if they are not able to perform, the license can either be cancelled or the license can be converted from exclusive to a non-exclusive license. So the other option is the sole license. So sole license, it's a kind of an exclusive license, but in this case, the technology owner can also use it. That means licensee and licensor both can use the technology, but obviously the licensor cannot give the technology to other companies. They cannot license the same technology to other industries. In practice, the exclusive license can be sole license depending on the terms and conditions. So if we are giving an exclusive license to an organization and we are writing one clause which says that the licensor or the technology owner can also use the technology. In that case, it will be called as sole license. The next type of license is non-exclusive license. It is very common license and usually this is being signed by the technology owners. So in this condition, the licensee is one of several licensees with whom the licensor has entered into agreements for the use and exploitation of the technology. That means here the licensor has given license to use and exploit the technology to multiple industries or multiple organizations. Okay, so there are more than one licensees in this condition, which means the licensor is not depending on the success of one licensee. So if I have given license to 5 companies and one company is not able to perform well, so it doesn't matter. I'm not depending only on that one company. There are 4 other companies who are performing well and they will help me to generate the revenue. They will help me to manufacture the product and commercialize it. And when we are talking about the license, it can be further, the research can be done further and that can be developed in a better way. So here both the licensor and licensee, they can work together and they can rework on the technology so that it should perform in a better way. So all these conditions will be there in the license agreement. Then the other form is cross license. So cross license in simple language, it is give and take. So for example, there are 2 parties. Both parties are having a technology, we can say a protected technology, and are covered under IPR. Like both the companies are having patent and they have rights to stop others or take an action against the other person who is using their technology. So in this case, both parties own IPR of interest of each other and have legal rights to prohibit other from using it then each party may allow the other party to use and exploit its intellectual property through cross licensing of IPR. So, for example, I have a patent for a product, and there is another company, they have a patent on a process to manufacture the same product, which is already covered under my patent. But the process this other company is having, it is less time consuming. It will help to save the money, like the expenses would be on lesser side because the raw material is uh, required in less quantity. Certain uh, substrates are not required. So in this case, both the companies can collaborate with each other, and I can give, I can allow the other person to use my product, and in the return I would ask them to allow me to use their process. So, and in this case, the royalty payments may or may not be involved. It depends on the value of IPR owned by each party. So, for example, we both have important technology, and which is having a sort of equal value. So, in that case, there may not be any royalty paid if we are cross license. So the next step is like types of rights. Okay, so uh, we need to explain what kind of rights are we going to give to the licensee. This needs to be written properly in the license agreement. The rights can be given to reproduce the technology, to modify it, to make derivative work from it, to use it for research and development, to make it or maybe manufacture themselves, or they can assign it to someone else to manufacture, or to distribute or sell it, to import, or to sub-license. So when we are talking about sub-license, here the licensee can sub-license the technology to any third party if required. So all these things, these should be clearly mentioned in the agreement document, and because that is the scope of the license agreement. These are the activities which are required to be done by the licensee. Then we are talking about geographical scope. So here we need to explain the territory. We will have to write whether the license is being given only for India, or like certain parts of India, or maybe if it's covering multiple countries. It depends on the market, because if we are giving license to any MNC or multinational companies, they might be having offices in more than one countries. They would be having industries in more than countries. They are capable of exploit and commercialize the technology in other countries as well. So in that case, we will have to mention the geographical scope very clearly in the license agreement. If we are giving the rights only to exploit the technology in India and it's not valid for other countries, it should be properly written in the document. So now as we discussed, there are two parties involved. So obviously there would be obligations of parties. So when we are talking about licensor's obligation, licensor is the person who owns the technology, who worked on the technology. He knows everything about the technology. Then he should oblige to give all the required technical assistance to the licensee. The person should give the know-how and the methods of manufacturing the product and all other technical details to the licensee. And if required, they can arrange for the training session for the licensee or the other people who would be working on the manufacturing of the product. So all these are obligations from the licensor's point of view. Then if we talk about licensee's obligation, so the main important obligation is to successful execution of the technology. They should be able to execute the technology in an industry. Means they should be able to manufacture the product, and they then later on they should be able to commercialize the product in the market. That means they should be able to sell the technology. And the licensee should pay the royalty within the given time. The timely payment of royalty is very important. And then licensee should also keep a book or accounts. So in like at any stage, if licensor wants to audit the accounts of the licensee, it should the account statement or account document should be ready with licensee. They should maintain the proper records of it. And if licensor wants to audit licensee's account, the information or maybe that particular clause should always be mentioned in the license agreement. So now comes to the financial terms, which is the main feature of the license agreement. Like what should be the consideration value, and then how should it be paid. So when we are talking about the payment of everything, all this is only for the revenue generation basically. So there can be different kind of terms. So one is upfront payment. So when we are talking about upfront payment, then a lump sum payment would be given at the time of signing the agreement. So there can be two types of payment. One is full consideration value is being given to the licensor by the licensee at the time of signing the license agreement. So if full consideration is already paid, licensee will not pay anything else to the licensor in future, as it's already all the amount has already been paid. Then there is another kind of upfront payment where a signing amount can be paid at the time of signing the agreement. So this is like an advance payment. So when we are signing the agreement, the licensee can pay X amount as an upfront payment, that can be a lump sum amount, and the balance payment can be covered in other two steps. It can be based on the milestone payments or royalty payments. So when we are talking about milestone payments, so here the lump sum payment to be paid on occurrence of specific events, which may be time based or performance based. So for example, there are milestones. When we are working on a business, we put in the business, if you see the business idea, there would be milestones mentioned. So for example, if we are talking about the technology transfer, once the license agreement is being signed, the license start manufacturing the technology. So there will be maybe different parts during the manufacturing process, and then during the commercialization process, and once the sale is done, after that also there can be multiple milestones. So all the balance payments can be decided based on these milestones. So when we are talking about milestones, there are two kinds of milestones. One is time based and one is performance based. So when we are talking about time based milestones, that means for example, one X amount is being paid at the time of signing the agreement. Then it's like every year the licensee would be paying something to the licensor, which this is called as time based payment, which is actually in a better way if we consider from the licensor's point of view, because it's fixed. So no further action is required by either the licensor or the licensee. The other type of milestone is performance based. So where the condition can be like when all the product, like X number of products have been manufactured, or if the licensee has sold 1,000 products or 10,000 products. So based on that, the payment can be made. So the only difficult point here is if event do not occur, no payment will be made. Therefore, the events have to be clearly defined in the document. And the third option is to make the payment in the form of royalty. So there are different type of calculations how to calculate the royalty. So it depends on the percentage of revenue from the products. So whatever revenue is being generated by the licensee can give X amount or maybe whatever percentage is being agreed, he can pay that amount to the licensor. So it can be based on the revenue. It can be some percentage of gross profit. This can also depend on the return on R&D cost for developing the IP or industry norms. So when we are talking about industry norms, certain kind of industries, they have a fixed royalty, maybe 2% or 3%. So it can be paid on that also. And then royalty can be on per unit sales. Like how many products I'm selling, I would be giving like some percentage of per unit sale in the market. There is a very important case here. So we know that there is a war between, it's not a war, but it's like Coca-Cola and Pepsi, they both are competitors. So this is very old case. So the person, so they used to buy some others bottles and they open the bottle, fill something else. So these are the things which is being done by both the competitors. So then there was an inventor who actually invented the can, the tin can what we use these days for the cold drinks. So when the can was invented, the person or inventor, he was contacted by both the companies. Both the companies are interested to buy his patent because he already filed patent application, and they were ready to pay anything for this product. Because if you see, like if you open the can, you cannot close it again. Like once it is open, like you will have to throw it. This cannot be reused. So at that time, the person, obviously both companies were negotiating with him, and then the inventor has asked only one condition. He said, "I want you to pay me 1 cent for each can you would be selling." So you can consider the person, like after some years, his revenue was more than the revenue of both the companies, because that was very important invention. So that's why like, the royalty, it can be depends on the per unit sales. Then we can discuss about sliding royalty. So royalty, it can be increased or decreased. So first we'll discuss about increasing the royalty. So we know that the licensor and licensee both are sharing the risk while commercializing the product in the market. When both are going to launch the product in the market, they both are sharing the risk. So the licensor may not get royalties during the initial market days because it takes time to launch a product, and the licensee is investing his own money towards the research and development. So in this case, both a licensor and licensee are compromising, where the licensor is not getting royalty and the licensee is spending money. So once the product is launched and the sales of the products pick up, the licensee recoups its investment and the licensor share of royalty increase, where they can increase the royalty percentage. If you see the example, so for example, like still like before 1000 there can be zero royalty because the licensee is not able to sell sufficient products in the market. So as the sale number goes, the percentage of the royalty can increase. So the numbers I have given, that this is purely an example, and what should be the percentage of the royalty, what should be the sale quantity, can be decided by both the parties, licensor and licensee. So the other form is decreasing royalty. It is not always that after sell the product, the royalty will always be increasing. Increase also, because when we launch a new product in the market with a very good technology, then usually the product is being launched at a high price because it is unique, okay, and new, and the public or the customers or consumers are ready to pay anything for that particular product. But as and when the sale increase, the product value will decrease. This is not only to appeal a larger market, but this is to discourage possible competitors. Because when you launch a product in the market, then you can have multiple competitors. So if you keep selling the product on high price, then your competitors can reduce the price and it will affect your revenue and sales a lot. So in this case, when the product is being sold at high price in initial days and later on the price was reduced, the licensor is actually not suffering loss because he got a higher percentage of royalty during the initial period of selling the product. Here you can say when the sale was less than 1000 products, the royalty was 10%. And at the sale is increasing because we are decreasing the price, we can also decrease or reduce the percentage of the royalty. Though there are trends in royalty payments when we are talking about per unit system or per product sold in the market, it is not affected by falling prices because I'm getting the royalty based on the number of products being sold in the market by the licensee. And sale dependent royalty is better because it depends on the market and the licensee, because sometimes the product prices go up based on the performance of the product and based on the market. So if the product price is going up, in that case the sales dependent royalty is a good option for the licensor, because the licensor would be getting high royalty in this case. So there can be an option of flexible royalty where the royalty percentage is not fixed. This will help to take care of price fluctuations, because when we are discussing about market, there can be a price fluctuation. So if we don't have flexible royalties, it would help to accommodate the price fluctuation, and then it will help both the licensor and the licensee. So what should be the royalty rate? Like how to determine the royalty rate? For this, both the parties should sit together. They should discuss on the royalty rate, and both the parties should be satisfied with the numbers. Whatever would be the royalty rate, it should be mutually agreed by both the parties. It also depends on the nature and geographical scope of the license. So when we are talking about nature of the license, as I told, the license can be given to manufacture the product, to sell the product, to use the technology, and there are multiple other things. So if the licensor is giving multiple options to the licensee, then obviously the royalty rate will be high. And same thing, if the license is being given to cover the broader jurisdiction, then also the royalty rate would be high, because if the licensee is allowed to use the technology in multiple countries, so obviously the licensee would be making more revenue. Then he should share the profit with the licensor as per agreed. Then then it also depends on the strength and importance of the intangible asset. So when we are talking about intangible asset, intellectual property rights, it's being considered as intangible asset. So how important or how strong is my intellectual property, that will also help to finalize the royalty rate. If the very strong, if the claims of the patent are covering the uh, technology in a broader way, then that means the invention is being covered broadly. Like in that case, the royalty will be on higher side, and the royalty rate, it depends on the continuing sale. And then commercial obligation undertaken, what kind of commercial obligations has been taken by the licensee, it that also help to determine the royalty rate. And the main important feature, the which party is very good in negotiating terms. Whoever is the party, those who have good negotiating properties, they will be able to negotiate well, and they accordingly the royalty rate can be defined. There is an example to define the royalty rates. So this is being used in evaluation of the technology, or what should be the royalty being given to the licensor by the licensee. So this is called as rule of thumb. So I suppose there is a lecture being scheduled tomorrow on valuation. So there, Mr. Jacob, he would be covering these things in detail, like how to evaluate the technology and what should be the numbers. So I'm just briefly covering it here, the basics. So rule of thumb, it is IP assets value is around, this is 20% of the gross profit before taxes from the operations in which asset is used. Okay, so this is the simple formula is 20% of the gross profit before taxes. So if I give you an example, for example, there is a product and the expected sale is 20,000 rupees, and the cost of manufacturing the product is 10,000. Then it can be considered that profit before tax is 10,000, because when we are commercializing the product, there are taxes involved. But in this rule, the tax is not being considered. So the gross profit or operating profit is 10%. So if we say the licensor should get 25% of this 10,000, which is 2,500 as the royalty. So this is also an important part of the license agreement. What will happen if there is a dispute between the parties at a later stage? A dispute can be related to anything. It can be related to the payment of royalty or fee, where the licensee is not paying the royalty in time, or if the licensee is not paying the royalty amount which was approved or which was accepted during signing the agreement. This dispute can also be related to the delay in completion of project, It can be related to the kind of information licensor is giving to the licensee. So earlier we have discussed the obligation of both the parties. So if any of the parties is not performing their duties, then there can be a dispute. It can be related to IPR issues also, and that it can be for quality and cost of the production. So we should know when we are signing the agreement, we should know like what will happen if these disputes arise. So one option, both the parties can sit and discuss mutually and then resolve the dispute. For example, there is a dispute related to the payment of the royalty. So at the time of signing the agreement, the royalty amount was discussed as 25%, but because the sale is not happening in a better way, or if the licensee is not able to sell the products what was planned earlier, so they both can sit and they can discuss, and then it can be discussed that these are the reasons of for like cause of which I'm not able to pay the royalty. I need more time. So these are mutual discussions, and if both the parties agree after the discussion, the dispute can be resolved with this. And then there can be an arbitration. So arbitration, it's a legal process where one arbitrator would be there, like the arbitrator would be a third person who will help both the parties to resolve the issue. The arbitrator can be appointed by the government, or any of the parties can also appoint an arbitrator. Both the arbitrator would be charging a fee. So the work of the arbitrator is to talk to both the parties, understand the issue, and then help them to resolve the issue. There is one important point which is required here related to arbitrator, that the arbitrator should not have any interest in any of the parties. This is because so that the arbitrator should give neutral decision, that he should not be biased with any of the parties. And then we need to write about the governing laws. So we can decide like which laws to be followed to handle the disputes. For example, like some of the license agreements I have worked on, where the arbitration is being jurisdiction for arbitration was being considered as Singapore, because in Singapore the time for arbitration is less, like you will quickly get the results. So if we are selecting Singapore as an arbitration center, then the Singapore laws would be governed to resolve the issue. The only thing, if we are selecting Singapore and the one company is Singapore company and another company is Indian company, then the Indian company, they would be facing difficulty, because if arbitration is being happening in Singapore, then obviously you will have to travel, you will have to spend a lot of money, all these, some difficulties would be there. So next is, so once the dispute we have already discussed. So next is intellectual property rights. So we have earlier discussed about intellectual property rights, where we discussed the intellectual property rights on the technology before signing the agreement, that completely owned by the licensor. Now, here we would be talking, because once the license agreement is being signed, both the licensee and licensor may further work on the technology, or maybe during the commercialization process, or during further research. Then there is a question, who would own the IPR on the new technology or improvements or derived technology. Then again it would be decided by both the parties. but it should be clearly written in the document, like who would own the intellectual property rights related to improvements or advancement or derived technology. It can be licensor, it can be licensee, or if both were involved in further research, then both can own the intellectual property right. Then there is an indemnity clause. This is to safeguard both the parties. For example, so both the parties will mention this as per their interest. For example, during the manufacturing of the product, there is the licensee is infringing someone else's patent. Then, in this case, licensor is not responsible for this. So here, the safeguard is with the licensor. Then, if the licensor has has infringed someone patent, which is purely depend on his technology, then the licensee is not responsible for this infringement. So in this case, like whoever is responsible, only that person, maybe licensee or licensor, would be responsible to handle the infringement matter and all the expenses related to the infringement. So obviously, when we are talking about these agreement, as I said earlier, confidentiality is very important. So when should we discuss about the confidentiality? One, during the early stages of negotiation. So when negotiation is happening and then the agreement is not signed, at that time the technical information should keep confidential. Otherwise, the non-disclosure agreement should be signed between both the parties. And as I said, the licensor can have prepare an abstract or summary of the of the technology, and that can be disclosed with the parties at the time of negotiation. This will help to keep the confidential information remains with the licensor. The other option, the confidentiality should during the executing the agreement. When you are executing the agreement, the process of execution the agreement, you have to keep the confidentiality because the agreement is yet to be signed. There are chances if there is any dispute, the parties may not sign the agreement. That's why that all this confidential information should be kept safe. And then another part is after expiry of the agreement. So for example, the license agreement is being given for 5 years. What will happen after 5 years? So anything, any information, any confidential information that should be mentioned in the agreement, what will happen to confidential information after expiry of the agreement. What should be the term of the patent? It is a mandatory step. Like you should know like how long the licensee should use the technology, and it can be defined in the agreement. It can be for limited period, maybe for 5 years, 10 years, or maybe for 1 year. It depends how the parties mutually agree. And the license agreement can also be given for the lifetime of patent. So when we are talking about lifetime of patent, it's 20 years from the date of filing. So once the patent is granted, it also depends. So the clause can be written clearly what should be the term of the license agreement. Then we discussed about license agreement. There can be many other agreements being signed during the transfer of the technology. The first we can say preliminary agreements. For example, it's an NDA, non-disclosure agreement. People usually sign on NDA with other parties when they are going to disclose the confidential information, or if they are sharing any technical information. Then IP rights agreement. There can be multiple agreements related to different forms of IP or different kinds of IP. It can be patent assignment agreement, patent license agreement, or trademark license agreement. And then there would be different agreement related to development and collaboration. All these things cannot be covered in license agreement. Okay, so license agreement would talk about licensing the technology from licensor to the licensee. Apart from this, when the licensee is developing the product, or if there's a collaboration between the licensee and licensor, there will be a separate agreement explaining all the terms and conditions of the development or manufacturing the product or of the collaboration. Then obviously the manufacturing agreements would be different. So all these things we have discussed about, like, so once the license agreement is being signed, then the licensee alone or the licensee in collaboration with the licensor can start commercializing the product in the market. So if we consider in India, there is like from the technology transfer from public funded research institutions to industry. So in India, there are in sometimes there are special cell or departments in the research organization or in universities. Okay, where the specified cell or department, they help the institute to commercialize the technology. I have listed some of them. So Antrix is there for ISRO. CTEC of the CTEC is a department of DRDO, Defense Research and Development Organization, where the CTEC is helping DRDO to commercialize their technology. So as like this, there are multiple departments or a specialized cell which are helping to commercialize the technology, or maybe they are helping to transfer the technology to the industry from the institute where the research is being done by the institute. The research can be mostly it's a government funded research. So for example, FITT is there, Foundation for Innovation and Technology Transfer. This is associated with IIT Delhi, IIT and IIT Bombay. They also have these kind of departments. Now you can see there are incubation cells in the university or IPR cell in the university. So usually IPR cell in the university, they help to protect the technology developed by different departments or different labs of the university. Then there are incubation centers. So incubation centers, they help to develop the technology, and sometimes they help to transfer the technology. They identify the licensing. So these are the parts or departments of a research organization. Apart from these, there are interfaces between research organization and industry. So it's like the liaison between, they would be in between, they would help to research organization to transfer their technology with the industry. So for example, NRDC is there, National Research Development Corporation, and Biotech Consortium India Limited, BCIL. So these institutes, they help the research organization in technology transfer. So if you check their websites, you can see a list of technology which is already being transferred, and then you can see a list of technology which is available for transfer. Like they have the technology with them, and they are for the industry who are interested in buying the technology, or maybe to get the license for the technology. And they have different kinds of arrangement. For example, NRDC, So one option, so sometimes obviously if they are helping the research organization to transfer the technology to an industry, there is a revenue involved in all these things. So one option, they can have like X amount out of the transaction deal. So it completely depends on these are the mediator, and they would help. They are working with research organization and industry both, and they understand the problems faced by researchers, and accordingly they help them to understand the technology, and they find the industries who are interested in the technology. So let's discuss some case studies. So I have taken two case studies. Those are not recent one, but the old studies. So one case study is related to liposomal amphotericin B. So both the studies were handled by NRDC. So for this is related to an antibiotic obtained from Streptomyces species. And here the research was done by Professor BK from Delhi University. He was in Department of Biochemistry, and he had developed the technology and developed the product. So this particular project was funded by Department of Biotechnology. So once the research is done, this was transferred to GS Medical College and KM Hospital, Mumbai for clinical evaluation. So once the clinical evaluation is done, once they have the final product after the clinical trial, the Department of Biotechnology who funded the project, they have handed over this to NRDC, licensing and commercialization. So NRDC, they have started contacting the companies. So that first licensee, it didn't happen. The first attempt was failed with Ace Diagnostics and Biotech Limited. Then later they have contacted Life Care Innovation in 99, and it was licensed and commercialized the product. So that time the license fee was 25 lakhs and the royalty of 3% for 10 years. So now you can say in 1999, so amount, it depends on the market or maybe the value of rupees. So 25 lakhs at that time, but if you see the royalty fee usually falls between maybe 3 to 5%. That is an average royalty being given to the technology owner. So this is another case study where this was related to the animal, where the animal is infected with lineage 4 virus, and there was no vaccine available in India at that time. Okay, so IVRI, the Indian Veterinary Research Institute, they were funded by ICAR, and they have started working on the technology. They developed the vaccine. Once the vaccine is developed, it was again transferred to NRDC for commercialization. And NRDC, they have identified Indian Immunological Limited, Hyderabad, and Intervet Limited, Pune, two companies. And then the agreement was signed in 2004. Here you can see the license fee was paid 2.5 million. And with a royalty of 3%. So you can see the royalty is kind of same. As I said, it is usually 3 to 5%. And so now the companies, and they have started collaborating with the universities, with research organizations, or with SMEs or small medium enterprises. So, and they help in, so for example, there is an industry university collaboration where the industry is collaborating with an university, where they help the university or researchers to develop the product, or maybe to continue the research, and then they help in the technology transfer as well, because the industry is already established. They are capable of commercializing the product. So in the collaboration, if the product is being developed, then the product can directly be commercialized by the industry. So in this case, we don't have to look for the buyer or look for the industry who is interested in the technology. All the agreements would be signed initially before the research is being initiated, because the industry is collaborating with university, so they are funding the research also. So like some of them are like IIT Guwahati. So Samsung company, they have started a collaboration with IIT Guwahati, where the digital academy to train more than 300 people on cutting edge technologies like AI, machine learning, IoT. So you say like current technology is depend on AI, machine learning, and then IoT. That's software, or everything is on cloud. So Samsung has started collaboration with IIT Guwahati, where they are funding the project and they are also helping the research to understand the technology. They are giving training to the technology. They are providing all the expenses and all the facilities to conduct the research. And similar, the Sterlite Technology Limited, they have collaboration with IIT Delhi. This is related to 5G technology. And then ESPN, they are with IIT Technology, and then they are launching a tool called SuperStats with a combination of statistics and data science to analyze cricket statistics. So I have covered more like general myths with CFTRI. So they are basically particular ingredients on volume and structured development in baked food system. Then Strand Life Sciences and Manipal College of Pharmaceutical Sciences and IISc. So it can be for a specific project, like collaboration can be for a specific project, or it can be related to specific domain also. Because if you see the Samsung, they are focusing on the technology, AI, machine learning, IoT technology. But if you see the other collaborations, it can be on a particular project. For example, when in the research organizations, where when we are doing research on a project, we get funds from that ministry. For example, Department of Science and Technology or Department of Biotechnology. So that can also be the collaboration, that industry is collaborating with university to help on one specific project. Otherwise, they can focus on particular technology as well. So then there are some collaboration on with MSME. So MSME, medium, small. This is micro, small, medium enterprises. So here BSF and Bombay College of Pharmacy, they are developing computational economic methods to predict and understand drug resistance. Then Sampuran Agri Venture Private Limited and Punjab Agriculture University. Then Pratishtha Industry Limited and ICR, where MSME is collaborating with universities or institutes. So for further research, and they both are conducting the research together. And in this case, there is an option once the research is done or once the product is ready, they both in collaboration can launch it. Otherwise, they both can look for the licensee, and the technology can be licensed to the industry for the manufacturing and commercialization. So now comes to the conclusion. So what we discussed about the transfer of technology from person or a company to another person or a company for manufacturing and commercialization of the technology. So when we are talking about successful commercialization, it's a long-term association between the licensee and licensor. That's why the terms of the license should be win-win for both parties. The terms of the license are like that both parties should be satisfied with it. The protection of technology is very important before the negotiation or before disclosing the technology. And license agreement is an important document, because it will explain the obligations, the kind of license, the duties associated with the license, what would be the royalty or what is the fee for that. So therefore, the relation building between the technology transfer organization and licensee is extremely important for success. Because see, one person has worked on the technology. It's like one person, the licensor is the master of technology, and licensee, he knows about the market. So when they both collaborate, then they can successfully manufacture and commercialize the product in the market. That's why the relation between the licensor and licensee is very important. If they are working together, they would be able to successfully commercialize the product. And all these things obviously are depending on the license agreement. So I suppose I have covered a lot of things related to technology transfer and license agreement. So if you have any question, you can maybe start shooting it. I will try to.
Ma'am, there are some questions in the chat box. First one is, when we license an IPR to an associate company, do they also get ownership of it, or they are only allowed to use it?
It depends, like how. So usually it depends what is there in the license agreement. So there are two kinds of agreement. One is saying a license agreement where we allow or where the licensor allows the licensee to use the technology. Then there is another kind of agreement which is assignment or maybe patent assignment, which is complete transfer of the ownership. So in that case, technology owner, if he is assigning his patent to the industry, in that case, industry will be the new owner. The researcher or the earlier owner of the technology, they don't have any right after assignment.
Ma'am, the next question is, can someone publish immediately after filing patent application?
Yes, that can be done because you have already filed patent application, and the novelty is there. Like, you should not publish before filing it. Once you publish it, after that you can you should not publish before filing the application. Once you file the application, you can publish, even if you're looking for publication in technical journal. So it is always advisable to first file patent application and then go for the publication.
Ma'am, the next question is, does it mean once the secret is patented, no one else can use it?
So practically, yes. Once you get the patent on the technology, then as per the patent law, you will get the rights to stop others who is using or selling or commercializing the technology or what was covered in the patent without your permission. But there are some exceptions. For example, the patent can be used for research and teaching purpose. That may not be considered as an infringement. And in certain instances, government can also use it for their use.
Ma'am, the next one is, please mention briefly the list of areas of social sciences to file patents.
Oh, so social sciences, I will have to find. Like, I haven't handled any patent related to social sciences. I can check on this and maybe I can share this information later.
Thank you, ma'am. I think it's over. I would like to request Lakshmi to deliver vote of thanks.
I suppose there is one more question. Someone is asking on software algorithm, whether it's a patentable or not.
Okay, ma'am.
Okay, so when we are talking about software algorithm, so as per Patent Act, if it's software per se, like that means only algorithms, you cannot get patent on this. It is not patentable because patent law doesn't consider this as an invention. You can get copyright on this. So, but if you have a software and within a hardware, then it comes as a system or a product, then you can file a patent application for this.
Ma'am, one more question, sir. Where can we get information regarding patents in detail?
So it depends what kind of information do you need. If you check all these government website and there are organizations who are facilitating patent, they have FAQ sections. You can get patent information on that. Otherwise, you can contact any of the patent attorney if you want to understand. I suppose most of them would be happy to explain about the patent process. Or if there is anything, you can contact me. I will help you to understand the patent process.
Okay, thank you, ma'am. Lakshmi, please.
Yeah. Good morning, everyone. On behalf of IUCIPRS and all the participants, it is my pleasure to thank Shivani ma'am for being with us today in spite of her busy schedule. Ma'am, you have walked us through the technical and practical aspects of licensing involved in technology transfer, and I'm sure this will help bridge our understanding of the domains of knowledge creation, the IP protections available, and the licensing mechanisms which enable technology transfer. Thank you, Shivani ma'am, for the illuminating session. Now, let me
Thanks.
also thank all the participants for their ready interactions today. Thank you all. Thank you, ma'am, again. Thank you.
Thank you so much.
Thank you.
Participants, next session is starting at 11:15 a.m. Please be present.